ready?
Yes, Your Honor.
All right, defense, call your first witness.
The defense calls Erich Nowsch. And we'd like to invoke the exclusionary rule.
If there's any witnesses that are going to be called in this matter, you're already staying outside until summoned in by the marshal.
Please raise your right hand. Do you do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state and spell your name for the court's record.
Erich Nowsch, first name E-R-I-C-H, last name N-O-W-S-C-H.
Go ahead, sir, have a seat. Go ahead, counsel.
Thank you. We're just going to start with some background information, Eric. How old are you as you sit here today?
21,
And how old were you on the date of your arrest in this case?
19.
At the time that you were arrested in this case, were you attending school?
No.
At that point, how far had you gone in school?
To the 12th grade.
And why were you no longer in school?
Because the school that I was attending, they weren't really working with my education and the problems I was addressing. About not really understanding, the classwork, and the teachers didn't really want to help me. So during one of my IEPs, they tried to put me in a school that was like super far away. It was a bird.
Okay.
And I decided it'd probably be better if I just finished later or get adult ed, but I never made it through.
So did you drop out at that point?
Yeah.
How old were you when you dropped out?
18, 17.
And you mentioned at your IEP. What's an IEP? What does that mean?
Like learning disabilities, like people don't necessarily comprehend, or they may have like hearing disabilities, or learning disabilities, or visual disabilities, or speech disabilities.
And specific to you, do you know why you had an IEP?
My comprehension level isn't necessarily the best. I also was highly medicated, and it was hard to keep me in regular classes because of the, withdrawals or the side effects of the medication.
And you said it was hard to keep you in regular classes. Were you in special education classes while you were in school?
Yes.
And as far back as you can remember, when did you start having special education classes as opposed to regular classes?
It was like the 3rd grade, I believe.
And that's something that continued through to when you dropped out during the 12th grade?
Yeah.
Are you, since your arrest, have you begun going to high school again?
Yes.
And is that through the Clark County School District program with the Clark County Detention Center?
Yes.
How many days a week do you go to school?
Anywhere from, it's random, but usually they try to get me in school 3 times a week.
And what grade are you currently working in?
12th grade.
So you began the 12th grade when you were 17. You dropped out when you were, actually you have to answer that.
Yes.
And you dropped out when you were 18.
Yes.
And then you've been re-enrolled in the 12th grade since age 19.
Yes, ma'am.
And you're currently, that's been going on for about 2 years now, yes?
Yes.
I have not always been your lawyer in this case. Who was your first attorney in this case?
Augustus.
I apologize. Who was your second attorney in this case? I was your first attorney.
Augustus and Conrad Claus.
Okay. And during the time that Augustus and Conrad Claus represented you, did you guys have an occasion to talk about your schooling system, the fact that you were in special education classes?
Yes.
Is that something that you explained to them?
Yes.
Did you tell them that you had difficulty with understanding things?
Yes, I did.
Did you tell them you had difficulty with reading?
Yes, I did.
When you would have conversations with them, did you sometimes have to go over material violence?
Yes, absolutely.
During the time that, you also mentioned that you were medicated when you were growing up and through your school years. Did you talk to your attorneys about that?
Yes.
At some stage during their representation of you in this case, did you guys start talking about negotiations? Potential of resolving the case? Yes. While Augustus and Conrad Claus were representing you, did you at some stage begin begin talking about negotiating the case?
Yeah.
Okay. They talked to you about how there's two options in the way a case unfolds. That you can go to trial or you can resolve it?
Yes.
Okay. When's the first time that you remember talking to them about the potential of resolving this case?
Probably about, I would say probably like 4 to 5 months in, maybe.
And at that point, were you in this courtroom already with your case?
Yes.
Okay.
Yes.
So it was following the grand jury indictment.
I believe so. I think so.
And about 4 to 5 months in, how do you remember, did they come to you and tell you that the state had made an offer?
Yes.
And what was explained to you at that time?
That the state was offering a solid flat 12 years, and that then it would just be flat. There was, I'd do 12 and be done.
And who presented that offer to you?
Augustus Claus.
Did anyone else discuss that offer with you?
His investigator, Toby Capron, might have as well. I believe she did too.
When you had that conversation about that first offer of negotiation, were you told what title of the offense you were being offered to plead guilty to?
Are you asking like the charge?
Yes.
No, they didn't explain that to me at all. They just told me the solid flat 12.
Okay. And what was your response at that time?
I told them no. I said I want to go to trial.
Okay. Now, did there come a point later in time that you had another conversation that related to potentially resolving this case through a negotiation?
Yes.
When did that happen?
About maybe probably like 3 months later.
Okay. And who came and presented that offer to you?
Augustus Claus.
And in that meeting, what were you told?
I believe it was the same deal that I have right now. They just didn't explain to me anything about a consecutive or a gun enhancement. It was just a flat 10 to 25. They told me it was a second degree, and I think they said something about a child abuse and neglect, and I told them I didn't want that.
Okay. And that didn't have anything to do with the case that's in front of this courtroom, did it?
No, it was just the deal.
Okay. That you were told that there was going to be one offer in the case that's in front of this judge, and there would also be a plea that related to a second judge.
They didn't tell me it was going to be between different judges, but yeah, the cases were different judges.
Okay, but you understood that the two different charges were related, one for each case.
Yeah.
During that conversation, this second conversation, how did you respond to what they told you the offer was?
This time?
No, the second time, the meeting that we were just talking about, and they came to you the second time.
I told them no, I didn't want that, and I wanted to proceed to trial still.
Did you talk about the details of how that negotiation would work during that meeting?
A briefing of it. They didn't really get too much into details because I didn't want it.
Did you have any discussions that related to how, for example, sentences are calculated once you're in the prison?
No.
And did you have any conversations about the rights that are given up when you take a guilty plea agreement?
Yeah, they explained that part to me.
And did you go over the various other aspects of a plea agreement in that meeting, or were you just talking about numbers?
Can you say that over?
Were you talking about anything other than the numbers relative to the deal? Did you talk about, whether, the judge gets to decide something versus your attorney and the state might have stipulated something or anything of that nature?
I don't believe so.
Following that second meeting, did there come a time that you had a third meeting that related to negotiations?
Yes.
When did that meeting take place?
I want to say it was about maybe like 3 or 4 more months after the second one.
Okay.
So I've probably been down for about a year at the time.
Okay. And who came to meet with you on that third meeting?
Augustus, or Toby Caperon, and then after she left, Augustus came in. Well, she started to leave, and then Augustus came in, they both sat back down.
And that meeting took place at the Clark County Detention Center?
Yes.
Okay. What offer was presented to you at that meeting?
The same deal as the second time.
And what did you understand that to be?
They said it was a second degree, 10 to 25.
And who presented that offer to you?
First Toby Caperon did, and then after Toby did, Augustus did. Because Toby was getting up to leave, and then Augustus came in, and they both sat back down and started explaining stuff to me again.
And during that meeting, you stated that you were told it was a second and that the penalty range on that was 10 to 25. Was there discussion of any other charges or potential sentences?
No, just the battery, but they said it would get eaten up by the first case.
And what did you understand that phrase to mean, eaten up by the first case?
That it technically wouldn't faze me at all, like I wouldn't have to do time for it.
Did you have any discussions related to credit for time served and how that would work when you reached a sentencing phase if you were to accept that offer?
Can you say that again?
Did you have any conversations about the credit that you had accrued since your arrest? The credit that you had built from the day you were arrested till the time of that meeting, and how it would apply if you were to have taken that offer?
They briefed and they told me that it was up to the judge if, however he wanted to go about it, you know, he would decide if he wanted to do credit for time served or maybe restart the sentence.
And what did you understand that to mean when they told you that it would be up to the court whether you got credit for time served or you had to start a new sentence? What does that mean?
Well, from what they explained to me, it meant that he doesn't necessarily have to go by the deal. He could do whatever he wanted. He could give me credit for time served and, you know, give me, you know, anywhere within the range of like from the front number being 10, he gave me anywhere from 1 to 10 years as the front and anywhere from 1 to 25 as the back.
Okay. And in your mind during that meeting, During that meeting, did you have a conversation that related to what your best potential outcome at sentencing would be under the terms of that offer?
Can you say that again?
Did you have an understanding of what your best case scenario sentence would be if you were to accept the offer that was being discussed at that meeting? What did you think the best sentence you could get under the offer was?
Like a 4 to 10.
Okay. And what did you think your worst case scenario was under that offer?
Well, they told me that I'd probably get a 4 to 10 because we went to trial. That's what they could have got me.
Okay. But what did you think the worst potential scenario was?
Life without.
During that meeting, did you make a decision as to whether or not you were going to be accepting that offer?
Yeah, they told me I had to make a decision that night.
And so did you?
Yeah, but not really. You know, I didn't really want to, but you know, under pressure, you know.
Okay. And did you at any point seek additional time or tell them you still have questions or anything like that prior to telling them what your decision was going to be?
You said, did they ask me any questions?
Did you ask them for more time so you could think or ask questions?
Yeah, I did.
What were you told?
They told me no, they had to have a decision for the courts by morning.
Prior to the two of them leaving that meeting, Toby and Augustus, did you make a decision as to whether or not you were going to accept that offer as you understood it at that time?
Yeah.
What did you tell them?
I told them, yeah, I guess.
Okay. Did they then leave the jail?
Yeah.
And when is the next time that you saw your attorneys?
It might have been the next day, or I don't remember if it was the next day or when we came to court was the next time I saw them.
Okay. And the day that you're talking about when you came to court, would that be the date that you ultimately signed the guilty plea agreement?
Yes.
Okay. So we're talking about March 4th. On that date, Did you talk to your attorneys prior to court?
No.
You didn't speak to the attorneys prior to the judge taking the bench?
Oh, and while we were in court?
Yes.
Yeah, they spoke to me in the little room back there.
Okay, and you're kind of pointing back towards the door over to your left that takes you back towards the jail, the way you come in and out, correct?
Yes.
Okay, and you and I both know, but just so the record's clear, there's holding cells back behind that door?
Yes.
And that's where you're referring to, that you spoke with your attorneys?
Yes.
Who was in the room prior to the judge taking that bench, the bench that morning with you?
In the courtroom or in the?
I apologize, in the holding cell room.
It was just me and Augustus Claus.
And what were you two discussing at that time?
He was reading the plea deal to me.
When you say he was reading the plea deal to you, are you talking about the agreement that you actually end up signing?
Yeah.
Had you ever seen that document before?
No.
That morning, did you physically read that document yourself?
No.
Did your attorney, Augustus Claus, read that document to you?
Yes.
As he was reading that document to you, do you remember how that went? Do you remember him doing that?
Yeah.
Can you summarize how that began?
Well, he came in and he asked me how I was feeling, and I said, well, I'm not gonna say I'm feeling good about this, you know. And then he was like, okay. And then he said, I'm gonna read this to you real quick. And then he just started reading it, and he was just reading it really fast. But he just started reading it, and then when he was done, he asked me for my signatures and told me where I had to sign.
Okay. Did you guys talk any further about what the negotiations meant during the meeting?
No, he just told me to say yes to everything that, you know, the judge would ask.
And what do you mean when the judge would ask? Did he describe to you that you were going to come back into the courtroom, that the judge was going to ask?
Asking numerous questions, yeah.
Okay, and how did he explain that process to you?
He just said the judge is going to ask you numerous questions based off of, he showed me the page that he had just read it off of, and he said you're going to answer, and he said you just have to say yes for most of them.
So, do you then come back into the courtroom that morning?
Yes.
And when you come back into the courtroom, are you seated in the box over here, or are you seated at counsel table with your attorney?
I believe I was sitting over there.
And
I think I was sitting over there.
and where was your attorney?
I believe at the table, or he might, I don't remember. I think he was at the table.
And obviously the judge then calls the case, and the judge begins to ask you questions about the document that you just signed, correct?
Yes.
Where was your attorney while those questions were being asked?
I don't remember if he was standing next to me or if he was at the table. So I think Conrad was here too. I don't remember if they were at the table or next to me. I don't remember, honestly.
And the judge asked you a lot of questions that morning, fair?
Yes.
And as you know, you and I have discussed this previously, but your answer to all of the questions regarding your understanding was yes.
Yes.
Can you explain why you said yes, yet you continued to maintain that you didn't understand at that time?
Well, they had explained to me everything about if I went to trial, they didn't have anything for me that could, you know, like no arguments or nothing. And that basically, with this deal, I had a date to get out, rather than being in prison for the rest of my life and never getting out. And so, under, you know, obviously, you know, being as young as I am, that scared the crap out of me. So I just did what he said. You know, I just listened to my lawyers. Everyone said listen to your lawyers. So he said say yes. And at the time, you know,
Can you remember what you were actually thinking when you were standing there answering those questions to the judge? Do you remember what was going on?
I was blurring out. I mean, it's like my whole life before my eyes, you know. I was kind of blurring out, you know, when he was asking me questions. I was just really nervous and kind of like I could see everything in front of me, but it was like my whole mind just like shut down.
Okay. Were you listening to the questions being asked of you?
Kind of.
a pre-sentence investigation interview. Do you remember the court ordering that?
Yes.
Did you and your attorneys have a conversation following the entry of the plea, but prior to the pre-sentence investigation interview taking place about that pre-sentence investigation interview?
You're asking, did I have a meeting with these people?
With your attorneys first, prior to meeting with the Department of Parole and Probation.
No, they were supposed to, but they never did.
Does there come a point in time where you had an interview with a pre-sentence investigation writer?
Yes.
Who was present for that interview?
The pre-investigation dude, and then Augustus Claus, and me.
And where is that interview taking place?
In the visit room and here in the jail.
And during that interview, did something cause alarm to you?
Yes.
What happened during the interview that you recall?
Well, after he was the pre-investigation guy, I don't know his name, he kept asking me like my background and, you know, my medication and, you know, my life and about my family and all kinds of stuff. When right before he was done, he said, well, I'm gonna request 4 years. And I'm like, and I looked at Augustus, and I'm like, okay, that's, you know, that's what I was thinking. And I was like, so just, and I said, can I ask you a question? He said, yeah. And I said, so just 4 years, or? And he said, well, no, 4 years, you know, to the second degree. I'm like, what do you mean 4 years to the second degree? He said, well, for your gun enhancement. He said, I'm requesting 4 years out of the 1 to 20. And I looked at Augustus and I said, I need to talk to you. And he said, we'll talk when he leaves. So I didn't, nobody mentioned anything about a gun enhancement and an extra up to 8 years to 20 years. You know, no one said anything about that.
So was that the first point in time that you realized that the second degree murder was one sentence and the deadly weapon enhancement was a second consecutive sentence?
Yes.
Had you had any conversations about consecutive sentences with your attorneys prior?
No.
Had you had any conversations about enhancement sentences prior?
No.
Did the PSI writer finish the interview and leave?
Yes.
And did your attorney, Augustus Claus, stick around and meet with you?
Yes.
What did you express to your attorney at that time?
First thing I asked him was, why didn't you tell me about this? And he just explained to me that I did explain this to you. I said, no, you didn't. I said, I'm pretty sure I'd remember if you told me this. You know, it's a lot of extra time. And he just started trying to tell me that he did tell me, and he didn't. And
did you have any further discussions about what you should expect at sentencing at that time?
No, because I asked him how to withdraw my guilty plea.
Okay. And obviously this meeting took place prior to the sentencing date.
Yes.
Do you remember what date this meeting took place?
I know it was the Friday before the week of sentencing. I believe my sentencing was on Thursday. It was the meeting with PNP on Friday.
Okay. You said that in that meeting, after you brought this up to your attorney, you asked about withdrawing your plea. What were you told in response to that?
He can't help me with that. He told me I had to fill out a motion, but he couldn't help me do it.
Did he explain that any further?
Yeah, he told me because we would be going against him. He told me to ask a jailhouse lawyer.
And did you pursue that any further with your own attorneys?
No.
When you left that visit and went back to your cell, did you do anything in relation to the plea that had been entered?
He actually did tell me he told me I might have been $1.01 too short.
Okay. And what did you understand that to mean?
He was telling me that it might be too late to even try and take my plea back.
Okay. Did you understand that phrase when he said it to you, or did you ask him what he meant?
I mean, I thought I understood what he was saying, but I asked him, and he said, well, you know, he said, frankly, you might not be able to do this since it's, you know, literally like the end of the week before you have sentencing, because Saturday and Sunday aren't business days, so.
And did you have any other conversations related to whether or not you were permitted to raise this issue with the court? Did you and your attorney, before he left, have any additional conversation about whether or not you were allowed to seek to withdraw your plea?
No, he just told me to ask a jailhouse attorney to find someone in my unit.
Okay. When you went back to your cell that night, did you take any additional action?
Yeah.
What did you do?
I was asking anybody and everybody, you know, how to go about this, and another inmate had just did a motion for somebody else in my unit, and so he said he'll do it for me too, and so I paid the guy like $20 to do this motion, and he did one for both of my court, this court and then the other court.
Okay. And is that the motion that was ultimately filed as a pro per motion by you?
Yeah, I don't know if it ever got filed. I know it got received, but I don't know if it got filed or not.
And that's something we've actually had a number of court hearings discussing with you, is that correct?
Yeah.
Okay. But the document that you sent out from the jail, is that the first time a document handwritten by you about your plea came to the court?
Yeah.
Okay. Whether or not it was properly filed?
Yeah.
Leave that for another day. Did you talk to your attorneys again prior to the sentencing date? So between the PSI interview date and the sentencing date, did you speak with them?
I honestly can't remember. I want to say I did, but I honestly can't remember.
Does anything stand out in your mind about conversations that related to the plea taking place between those two dates?
You know, as I think about it, I don't think they did. I think they took, because they had told me this will probably be the last time they see me since I was trying to fill out a motion to withdraw my guilty plea. It'll be the last conversation we had.
So the next time then that you are addressing this issue is actually in the courtroom at your sentencing date, is that correct?
Yes.
And at that time, your attorneys were taken off of the case, correct?
Yes.
And that's when my office was reappointed at that time.
Yes.
As you sit here today, what is it that you believed you were entering a guilty plea to plead guilty to?
As of today?
As you sit here today, what is your understanding of the negotiation?
Well, now I know that there's a 10 to 25 and 1 to 20. It can go anywhere from 1 to 8 to 20 years. That's on automatic consecutive, and the second charge is negotiable if they want to.
And that second charge, again, we're talking about a different case.
Yeah.
Okay. Is that understanding different than your understanding the morning that you signed the document?
Absolutely.
Briefly. We talked for a second about credit for time served and how you understood it to work. Did you have any conversations about good time credits?
No.
Okay. And so the only conversation you had in relation to credits was the conversation about the credit from the date of arrest through to the date of sentencing?
Yes.
That's what I said.
Any cross-examination?
Yes, Your Honor. Mr. Nowsch, you read and understand the English language, correct?
Yes, sir.
As you sit here today, sir, what is it about the guilty plea agreement in this case that you signed that you didn't understand at the date that you entered your plea?
The automatic consecutive for the gun enhancement.
And your testimony here today under oath is at no point prior to that interaction with the pre-sentence investigation writer from parole and probation, you had no idea you were entering a plea to second-degree murder with a deadly weapon enhancement. Is that accurate?
That's accurate, sir.
You never had a discussion with Augustus Claus about that?
No, sir.
You never had a discussion with Conrad Claus about that?
No, sir.
And you had never had a discussion with anybody from his office
No, sir.
about that?
No, sir, I'm sorry.
Now, when the court, on the day that you entered your plea, some 9 months ago, described the deadly weapons enhancement, did you say anything about it at that time?
Are you talking about inside P&B? Did I say anything about it?
No, here in court.
When we signed it in here?
When the judge was asking you questions about the entry of plea and discussing with you the deadly weapons enhancement, that was said during your canvass, the questions that the court had for you. Do you recall that?
Briefing of it, I was really nervous and kind of blurring out. I was just answering to everything he said. I was just saying yes.
Okay, well, that's not my question to you. My question to you is, do you remember that question being raised by the court to you about the deadly weapon?
I honestly want to say I missed it. I don't remember hearing him say automatic consecutive 1 to 20.
Was there any other portion of the canvass that you do not recall?
No, just that consecutive.
So out of all the, you've reviewed and discussed with these lawyers the transcript of that proceeding where you entered your plea, correct?
I'm sorry, can you say that again?
There's a transcript that was prepared of when you entered your plea. It's a written document that outlines what was said in court.
Yes.
That's what I mean by a transcript. You're
Yes.
comfortable with
Yes.
that concept?
Yes, I have it.
Okay. And you've reviewed it prior to your testimony here today.
Yes.
You'd agree with me in that transcript that talks about a lot of things beyond or besides the deadly weapons enhancement. You'd agree with that, right?
Yes, sir.
But under oath here today, your testimony is the only thing you don't remember was the court's questions to you about the deadly weapons enhancement.
Yes, sir.
You remember that there is a condition about you entering a plea in this case, but that it's also a requirement that you enter a plea of guilty in another case.
Yes, sir.
And you understand that today.
Yes, sir.
And you understood it the day that you entered your plea in this case.
Yes, sir.
And that is where the state alleges that you were prepared to plead guilty to holding a knife to a minor juvenile's neck. Does that sound familiar to you, sir?
I mean, yeah, I have the paperwork on it.
And you understood that at the time that your attorneys talked to you before you entered your plea, correct?
Yes.
You understood that at the time that you entered the plea in this court to this offense, correct?
Yes, sir.
And you understand that as you sit here today.
Yes, sir.
Now, you said that you were, and I wrote this word down in quotes, based upon the examination of your current counsel on direct examination this morning, that on the day that you entered your plea to this offense, you were, quote unquote, under pressure.
Yes, sir.
What pressure were you under, sir?
Well, my whole life flashed before my eyes. You know, we're talking about someone who came in at 19 years old, you know, looking at the next 10 to 25 years and, you know, just a massive amount of time, a whole decade of time.
So the pressure, there's no other pressure other than what you just testified to, is that correct?
Well, yeah, it's all time consuming. It's all the pressure with the timing and having to make a decision so quick, you know, under short notice.
Okay, well, my question to you was what kind of pressure, and you said the time, the amount of time that you had to serve as part of a sentence. The answer to your last question, I'm not sure if that's different, so I want to clarify that. What was the pressure that you described when you answered your question this morning, you felt, quote, under pressure on the date that you entered your plea in this court?
I felt under pressure to answer the judge. I was nervous and about sitting here saying, yes, I'm agreeing to all this stuff.
to the time that you would have to do.
Yes.
Is there any other pressure that you were under at the date that you entered your plea?
No, sir.
You made a, counsel asked you a question about a motion that you filed prior to these attorneys filing a motion to withdraw your plea. Do you recall those questions to you this morning?
Yes, sir.
That is what we refer to as a pro per motion. Are you comfortable with that term this morning, or would you like me to use another term?
Can you use another term?
Sure. Your handwritten motion.
Okay, yeah, that works.
Did you write that motion?
No, I did not.
Who did?
Another inmate, you want me to state his name?
Yes.
Another inmate named Michael Rodriguez.
And did you know Mr. Rodriguez for some period of time?
No.
Did you have anything to do with the contents of what's in that motion?
Slightly, yes. Yes, sir.
Explain that to me, sir.
I had explained to him my reasons that I wanted to withdraw my guilty plea. Just a quick briefing of these reasons and why, you know, what I was trying to do. I had tried to explain it to him, what I needed him to do the motion on.
So you'd agree with me that everything that's specific about your case is contained in that handwritten motion. In other words, besides the legal argument that you may or may not have had any involvement in, and we'll address that in just a second, the substantive portion, the portion that deals with what is wrong with your plea, came from you.
Yeah, yes, sir, but he mixed, he did a little bit of his own work on there. What he said he thought would help me with, because I didn't write it, so I'm not writing down exactly addressing every single problem, but he just addressed the main problems that I addressed to him.
Okay, and you reviewed it after he wrote it?
No, I actually didn't, because we were on such quick time consuming. He just sent it straight from his cell to the mail.
Prior to your testimony here today, have you reviewed it?
Yes, yes, sir.
Does it accurately state what your concerns about your entry to plea are?
Not all of them, but most of them, yes.
What one is not contained in there?
I don't remember exactly everything he put in there. I know he mentioned about ineffective assistance and my medical history and being unable to comprehend certain issues and certain statements. I don't remember exactly what details he put in there about them, but I do remember those were the main topics. There's a third topic he put in there too, but I don't recall what it was. I haven't read it for a while. It's been maybe like 2-3 months since I looked at it.
You mentioned that there was a request that you made to your counsel, and I will refer to them as the Claus brothers, that you had requested repeatedly discovery, but were not provided discovery items in this case. Do you recall that?
Yes, sir.
What items of discovery did you not get?
Statements, evidence vaults, police statements, voluntary statements, transcripts of the grand jury, what was being said against me under oath. Just really everything. They didn't give me anything. The only thing I had received was the transcripts from my confession video, because prior when we had the Jackson versus Deno, they gave it to me the night before. So that was the only discovery, any kind of statements or anything on this case that I actually had possession of.
And that was the only thing that, after you requested discovery, that was the only thing that your attorneys produced to you. Is that your testimony?
Yes, that and my charge papers saying what my charges were, and an indictment paper to the second case.
So you knew at least according to your testimony, the indictment in the other case, that is the knife against the juvenile's throat.
Yes, sir.
And you had the charging document, the indictment in this case, charging you with first-degree murder with use of a deadly weapon, among other felonies, correct?
Yes, sir.
Now, when you read that document, you saw that the state alleged you committed, in this case, murder with use of a deadly weapon.
Yes, sir.
So let me go back to the discovery issue. Besides what you just indicated here today, the 2 charging documents and a transcript of your confession in this case, those were the only items ever produced to you by your attorneys known as the Clauses.
Yes, sir.
Is that your testimony here today?
Yes, sir. Well, the charge papers too, I don't know if that considers the same category as the indictments.
Did you have a discussion with the Claus brothers about the potential range of punishments if you were to go to trial?
Slightly, but they weren't giving it to me about the whole deal. They were just telling me about the 10 to 25 specifically.
No, I'm talking about if you went to trial in this matter and you were to lose, you were convicted of first-degree murder.
Yes, they explained it to me.
Okay, and what, as you testify here today, what is your understanding if you were convicted of first-degree murder in this case, the potential punishment for it?
I would get life without.
And were you advised of any other sentencing possibilities?
No.
Do you remember having a conversation where Mr. Claus, specifically Augustus Claus, had a diagram outlining the potential punishments in years to you about various different options in this case?
Yes, but he didn't really, it almost seemed like college homework, the way he had it all mapped out. It didn't really, looking at it, it didn't really make sense to me, and I kept asking multiple questions about it, and just his answers kept changing. He was just using a bunch of like college words and stuff. It was getting confusing, so I just took it as 10 to 25. He explained to me that the judge would be able to make whatever ruling he decides, and if he wanted to do 1 year, he can do 1 year. If he wanted to do 10 years, he can do 10 years. If he wanted to give me life, he can give me life, or 25, or whatever he pleased.
Do you recall a specific meeting at the jail with Augustus Claus where he diagrammed for you in a visual format the potential punishments, certainly under the plea agreement, as well as punishments if you went to trial and were to lose, that is, you were to be convicted of first-degree murder?
Yes, sir.
Did he also discuss with you the potential defenses in this case that you had to the charges?
Of this deal?
To this case, if you went to a jury trial, and that you would have to try this case as opposed to plead guilty in front of a jury, what defenses were available to you? Did you have a discussion with your lawyers about that?
Yes,
Your
sir.
Honor? Okay, never mind. He's just asking me yes or no.
Go ahead, Mr.
Yes, yes, sir.
And was there also a discussion with him about concerns based upon what was contained in your mental health records?
Yes, sir.
That indeed going to trial was a problem because of what those records stated?
I don't believe he told me anything about that.
You're aware of what's in those records, correct?
Some of it, I mean, goes back to the age of 5 years old.
I agree it does. You're aware of what's contained in them?
Some of them, no, I haven't looked over them. I haven't been produced a copy or anything of whatever my mom had transferred to them.
Well, in those records, is it not accurate that part of the presentation to you or in various different mental health facilities was you had expressed at numerous times in your life an intent to kill others?
Your Honor, I'm going to object. This is one, outside the scope of the direct examination, 2, irrelevant to the proceedings, and 3, has no bearing on any of the issues that have been raised at this point at this hearing.
No, overall, the objection, one of the bases for the withdrawal, you're pleading this investigation of mental health issues, so I'm going to allow this line of questioning. Go ahead, Mr. Stanton.
May I just clarify the objection then?
I've overruled the objection.
Did you remember my last question to you, sir?
Kind of, if you repeat it again, just so I'm 100% sure.
Certainly. Is it true that part of your mental health records reflect that on numerous occasions you had expressed in different environments an intent to kill others?
I can't answer that because I was highly medicated. I was 5 years old on 16 pills a day. I don't really recall what I was telling those doctors. I did have suicidal issues against myself. At times I tried to take my life numerous times, which is what got me into those hospitals. But I can't tell you that I actually said that stuff because I don't remember. I mean, I was drug speaking, you know, it was all the medications they had me on.
Okay, well,
I don't remember the specific conversations that we had.
so is it your testimony here today that your recollection of statements that you made to mental health people and medical people in your past, you don't remember because you were so medicated?
Yes, sir.
Okay, I apologize if my question was confusing to you. I'm referring to the records that reflect that you made threats to kill other people, not to doctors, but in social environments, at school, at church, to others, to friends, to family. Not while you're sitting in front of a doctor, but in an actual social environment outside of a mental health or medical facility.
I don't recall. I just know that I used to talk about how I was going to kill myself. I don't remember talking about killing somebody else.
So you remember what we call suicidal threats, suicidal ideation, but you don't remember making any threats of homicidal ideation, that is the intent to kill others.
No, sir.
Do you ever remember reviewing those documents where they evaluated you as being paranoid?
The doctors said I had paranoia. I truthfully was in denial. I didn't think I did, but...
And did you have a discussion with the Claus brothers about that diagnosis, that specific diagnosis of paranoia, and how that would affect, and specifically negatively affect, your defense in this case?
You're asking if I had this discussion with my attorneys?
Yes, sir, that's what I'm asking.
Well, we kind of had a discussion about overall all the issues, from anger to suicidal to comprehension to, you know, how they made me feel, what medications they were for. But I don't think we had any discussions about paranoia.
Was there any medication that you were on the day that you entered the plea in March of this year?
No, sir.
So you'd agree with me there would be nothing that would prevent you from understanding what occurred in the courtroom?
Well, I want to take that back. I do take one medication. I take Lipitor for my heart, but I don't. It's nothing according to the pills we're talking about.
Well, you've been taking Lipitor since the age of 8, at least in my review of the medical records produced by your defense team.
I believe it was a little bit earlier than that, but yes, sir.
And you've been diagnosed for most of your life with high cholesterol, and that's why you take Lipitor.
Yes, sir.
Besides Lipitor, was there any other medication you were on in March of this year?
No, sir.
I'm sure you've reviewed the transcript. Did you ever review a JABS, that is the video recording of your entry of plea in March of this year?
No, sir.
Do you recall ever attempting to ask a question to your attorneys during your entry of plea, and your attorneys denied you the opportunity to answer any of your questions during your plea?
Sorry, can you ask me that one more time?
Sure. Do you recall at any point at the time that you entered your plea in March of this year, asking your attorneys a question or attempting to inquire of them and then refusing to respond to you when you were entering your plea?
Multiple times previous, but I don't know about in here. I don't think I asked them any questions in here.
I'm just asking you about here for right now.
No, sir.
Now, you claim, I believe, in the answer to the question I just posed to you, that there were times when you did have questions and they refused to answer them?
Yes, sir.
Can you describe that to me?
Well, obviously on the discovery issues, also I had asked them a few different times what exactly was going to happen with this plea, what exactly the worst possible outcomes were, and they told me that they had already explained it to me, and that you know, they don't want to come in if it's not going to be important or it's something we've already went over.
So was there times where they had answered that question to you and that you wanted to repeat it again? Or are you telling me that they never answered that question?
They did. When they came in to explain the deal to me, they said it then, but afterwards, I had asked them again because, like, you know, my mind was stuck on it. I'm sitting in a cell, you know, all day thinking about this, what the next, you know, years of my life is going to be. And so I came up with some more questions about it, and I didn't want to answer it because they've already went over with me inside the visitation room. They're going over the plea with me.
So that they refused to answer your questions when you asked them again to repeat things that you had already told, they had
Yes.
already told you?
Yes, sir.
Besides the deadly weapons enhancement, if I understand your testimony correctly, there is no other part of the negotiations, the guilty plea agreement in this case or the other case, the knife incident, that you don't understand?
Sorry, can you say that one more time?
Sure. If I understand your testimony, and I want you to be absolutely certain, the only thing you don't understand or didn't understand at the time that you entered your plea was the deadly weapons enhancement to the second-degree murder in this case.
Yes, sir.
All other aspects of the negotiation you understood.
Yes, sir.
Now, counsel asked you some questions about credit for time served and good time credits. Remember those questions?
Yes, sir.
Do you have any confusion about that at the time that you entered your plea about what credit for time served is and what good time credits are?
Well, yeah, they never explained that to me. They just told me it was up to the judge, whatever he wanted to do.
Okay, but that's not actually my question to you. My question to you is, at the time that you entered your plea, did you know the difference or know what those terms meant?
No.
You had never discussed that with your attorneys?
The credit for time served, meaning, you know, the time that I've been down, that counts, but they never explained anything about good time.
Okay, so my first part of my question is, you never discussed that with your attorneys at the time that you entered your plea, and the answer is yes, you never discussed it, correct?
Correct.
Did you ever discuss it with any inmates?
After the fact, yes. Before or while in here, no.
Is there anything about your understanding of good time credits now that is an impediment or a cause of your concern to tell you that your plea in this case is invalid?
Can you say that again?
Certainly. The issue of good time credits, does that affect in your mind the voluntariness of your plea in March of 2016 to this case?
I still don't know what good time credits is, but no, it's the gun enhancement.
Okay, I just thought you answered my question that you didn't know at the time that you entered your plea, but you now know what good time credits are. Am I misunderstanding your testimony?
I know from what other inmates have told me, I've never seen physical proof or had it come from an actual professional outside of this jail, no.
Okay, so has your current team of lawyers explained to you what good time credits mean?
No.
Does that, now that you know, or at least I believe you know, based upon your testimony, does there anything about good time credits that causes you to say that your plea in March of this year to this offense was involuntary?
I don't, excuse me if I made it in a different manner of understanding to you. I still don't know what good credits is. I've had the discussion with other inmates. You asked me if I had discussions with other inmates on it. I've had discussion with other inmates, but I still don't know what it is. I don't necessarily believe everything I hear from other people inside this jail. They just explained to me that something about every so-and-so amount of weeks without getting in trouble, it counts as a certain amount of days. Regardless to that, even if I did understand it, no, it wouldn't make a difference. I mean, the fact is I didn't know that there was an additional consecutive charge in this plea.
And that's the deadly weapon portion.
Sure.
And what your understanding about good time credits, whether it's accurate or not, you now say under oath that that did not have any impact in your voluntary nature of your plea to this offense.
No, sir.
So, just so the record's clear, it did not affect your plea in this case, your knowledge of good time credits.
I mean, I don't think so, but I didn't, it's not like I know. I'm trying to tell you that I don't know what that is exactly, so I don't necessarily know how I'm supposed to answer that question.
I want you to answer it truthfully. That's how I want you to answer.
I don't know what it means is what I'm trying to tell you, so.
Okay, well, if I understand your testimony, you heard from no lawyer, but people in the jail, inmates, about what they've told you they think good time credits means, correct?
Correct.
And you, probably correctly so, don't know if other inmates are being truthful to you about what good time credits is, correct?
Yes, sir. Yes, sir.
Okay. So my question is, whether you know through inmates or from the warden of the Department of Corrections about what the technical definition of good time credits is, does that affect your assessment of the voluntariness of your plea to this case in March of this year?
No, sir.
No further questions, Jim.
Any redirect?
Just briefly. We'll go back in. You said that you felt pressure to accept the negotiations on the morning that you came into court.
Yes, ma'am.
What was it about the meeting you had had the day before that led you to feel pressure?
Okay, they didn't really give me
I'm sorry,
any,
who's they?
Augustus Claus and Toby Caperon.
Okay, now continue, I apologize.
That's fine. They didn't really give me any time to sit back and think about the decision I was making, or did I have any discovery, so, I mean, I'm blindsided to everything. I'm just going off what they're telling me, and we're speaking about that's a decade, you know, we're talking about me getting out, you know, at 30-something years old, you know, worst possible outcome, you know, that's a lot of pressure for me to take in, considering I've never been in a circumstantial situation like this, and that's a lot of time, you know? So I was under pressure because I had like a few hours to make a decision, if that, maybe 2 hours at a maximum. They were probably in there with me, maybe less. I had to make a decision within that time frame so that they can wear the courts and proceed with what's going to go on. Yes, I had a lot of stuff going through my mind. I didn't.
Did that time frame impact the 2 hours that you mentioned, or roughly 2 hours? Did that impact the amount of pressure you were feeling to make a decision?
Absolutely.
Did you feel that, based on the information you were receiving during that meeting, that you truly had any choice in the matter as to whether to accept or reject a plea agreement at that time?
From what they told me, no, I felt like I didn't really have no choice.
And the next time you had a discussion related to the negotiations, when you were in the room outside of the courtroom here, about how long did that meeting take place?
Probably like 10 minutes if that.
And during that meeting, were you feeling the same degree of pressure as you had felt in the meeting at the jail?
Yes, evenly about the same.
And and that's the moment when you in fact signed the agreement, yes?
Yes.
Did you feel in the moments leading up to your signing of that agreement that pressure impacted your decision?
Yes.
Did you feel that you had a choice in the matter, given the conversations that had taken place over the preceding couple of days?
No.
I want to switch topics. You've said a couple of times now, you thought you could get a 4 to 10. Do you remember saying that today?
Yes, ma'am.
What is it that you thought you could be sentenced 4 to 10 years for?
Well, for the second degree, but from my understanding, they said that the judge can go anywhere within those lines of the deal. He can do whatever he wants within the lines of a 10 to 25, 10 being the front and 25 being the back.
Okay, and I don't want this to sound ridiculous, but where does the 4 fit into that?
Well, you know, from 1 to 10, you know, 4 is in between the numbers 1 to 10. So if they said what they would probably be able to get me as sentencing would be a 4, A 4 to 10, I don't know where the 10 came in. They just said that if we went to trial, they would have been able to get me a voluntary manslaughter, and it would have reducted to a 4 to 10 if the voluntary was maxed out.
Okay, so if I'm gonna split this up for a second, just so I know we're talking about the same things. Let's take out whatever potential you believed was available to you if you were to go to a jury trial. So take out any conversation related to what you thought a trial outcome would be. Strictly speaking about the negotiation, what is it that you thought you could receive that number 4 in relation to?
Well, I thought that I would do 4 years.
And what did you think that penalty attached to? Which of the offenses in the agreement?
The second degree murder.
Okay. But you agree that you were also, you were canvassed on the fact that the minimum was 10. So why did you believe you were also eligible for a number that was less than 10?
Well, that was one of the questions after we had left. That was one of the things I had started thinking about. It's one of the things I asked them to re-explain to me, and they didn't want it.
So in your mind, 4 was an eligible minimum term sentence to you.
I mean, it was better than...
Not an acceptable. That was something you were eligible to receive, not something you
yes,
wanted
sir.
or didn't want or anything like
Yes,
that.
ma'am.
Okay. Switching topics again. I know Mr. Stanton just asked you a number of questions related to both credit for time served and good time credits. Did you have a conversation with your attorneys about how the days from the date of your arrest through to the date of your sentencing would be applied by the court to a sentence when the court issued a sentence?
You're asking if they explained that to me?
Yes.
Yes.
Did they tell you that those days would count, would not count, or something else?
They didn't explain that to me.
Okay. Now, switching to the other topic, the good time credits conversation. Did your attorneys encourage you to re-enroll in high school while at the jail?
No, I did that voluntarily.
Did you do that because you believed it would have an impact on the sentence that you received? At least in part.
Yes, and because, I wanted to do something. If I had an opportunity to fix what I messed up in the past, I took that opportunity. It's something I have, because my IEP, I have until the age of 22 to get it, so I took advantage of it when it came to my face.
Did you believe that conduct such as going to school is something that the court could credit you for when determining your sentence?
I never put thought into that.
Okay. Brief indulgence. You mentioned your IEP again. Do you remember some of the accommodations that were made for you while you were attending school? Some of the things you got to do that other students didn't get to do in relation to your classwork.
Yes.
Can you describe a couple of those things?
You're talking about on the outside, right?
Correct.
Yes. Well, we had it. We watched a lot of movies. Our work wasn't quite as hard as normal classrooms. Our teachers in there, they worked one-on-one with us. At least I'm referring specifically to middle school. I know they were always, we had 2 teachers, and it was a less population in class.
And you mean there were fewer students?
Yes.
Okay.
So it was easier for when we didn't understand something, the teacher could come over and help us, one-on-one with it. And because in one classroom we had the ages, or the grades from 6th to 8th grade.
Okay.
So everybody was doing different work for the most part. And so, it really didn't leave them much of a choice but to help us one-on-one. So it was a lot easier in those classrooms.
When you were taking a test, for example, were you getting difficulty understanding assignment? Were you permitted to utilize a tutor?
Yes, and a calculator too, depending on if it was math or not.
Okay. And not all the students were allowed to use calculators, right?
No.
Were you given the option of taking more time with a homework assignment than some of the other students were doing, with different deadlines?
Yes.
And if you didn't understand something after you brought an assignment home, was there an accommodation that allowed you to meet with the teacher and have it re-explained to you?
Yes.
And did you sometimes have to have things re-explained to you in a number of different formats, such as letting you read it, someone saying it out loud, that kind of thing?
Yes.
Is that something that went on throughout your school age years?
Yes.
Did you have an opportunity to approach the negotiations in this case with your attorneys similarly to the way you were able to approach assignments at school?
No.
Did you have an opportunity to, for example, read over the guilty plea agreement document by yourself and keep it in your hands in your cell with you prior to entering?
No.
Did you have an opportunity to ever hold the document and read it yourself?
No.
Prior to it being signed?
Or
Yes.
after, but
I know
no,
you
not
did not.
before.
Prior.
No.
Did you have an opportunity to spend time with the decision you were making, to think it over a course of days?
No.
Nothing further.
Any prosecution?
Briefly. Sir, in fact, you had 9 months prior to the entry of plea in this case to think about the plea negotiations in this. Isn't that true?
Yes, sir. Oh, I think it's been 7, but
Nothing further here.
All right, thank you. All right, thank you, sir. Seat next to your counsel. Who's our next witness?
Your Honor, if I could have 30 seconds,
Sure.
maybe 45. No one further, Your Honor. Thank you.
All right. I'm sorry, no other time or no other witnesses?
Both.
Okay. So no other witnesses for the defense, any witnesses for the state?
Yes, Your Honor. Augustus Claus.
It was fast to me, but
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God. Please state and spell your name for the court's record.
Thomas Augustus Claus, Thomas, Augustus, Claus, Claus.
Right, counsel?
Thank you, Your Honor. Mr. Claus, prior to your testimony here today, I forwarded you at or near November 3rd, the date it was filed, Mr. Nowsch's instant motion before this court to withdraw his plea. Is that correct?
I believe so.
And have you reviewed the claims that were made in that motion?
I did it one time, yes.
Let me begin with claim number 1. and ask you a question about the mental health records that exist regarding Mr. Nowsch's past history. How are
Can I
you?
stop you for just a moment? Your Honor, as I understand the posture of this case, the attorney-client privilege has been ordered waived at this point.
That's
I'm
correct.
required to testify.
That is correct.
I'm sorry, Mr. Sanchez.
It's okay. Did you have, to your knowledge and to your belief, sufficient mental health records involving Mr. Nowsch in his pre-adolescent, adolescent, and early adult years?
I believe I had sufficient records, but for what purpose are you specifically referring?
I'm just asking not for a purpose yet, but whether you possess them.
Yes, we did possess a number of Mr. Nowsch's medical records and mental health records.
In relationship to that, in other words, in addition to the records themselves, you had access to an historian about his background, Mr. Nowsch himself, as well as his mother. Is that correct?
That is correct.
And was his mother an active participant in interacting with you and your legal team in representing your client?
To the extent that she could. It made her very anxious, but she tried as best she could.
Was there anything about your knowledge of the mental health records that caused you concern about his inability to understand the negotiation process in this case?
No, not that I can think of.
If at any time there was an incident, would it have been your habit and custom to seek some sort of evaluation to address your concerns?
Yes.
Has that happened in your career where you had clients where you had either minor or major concerns in that regard?
Yes, it's colloquially referred to as competency court, but it's essentially a court that's specially designated for determining the competency of defendants.
And how many criminal defendants have you represented in your career?
In my career,
Today, as you testify here today,
I don't know.
would it be in the thousands?
Yes,
And would that be that on other occasions, when you had those concerns, you have taken the legal steps to address whether or not there's a mental health component with your client in understanding either the preparation for trial and defense or in understanding in negotiations?
yes.
Did any of those concerns give rise in this case with this client, Mr. Nowsch?
Well, Mr. Nowsch had several concerns that had to be laid to rest. The first was his youth. He's a relatively young man with some prior experience in the criminal justice system. That always poses a bit of a hurdle. His prior experience has been in the juvenile justice system, so he needed to understand that the adult justice system works fundamentally differently. But in terms of, did I ever send him to competency court or think that I should, the answer is no. But he did have areas in which I needed to satisfy myself that he understood what was going on.
And during the course, and once again, I'm talking about the entirety and the breadth of your representation, was there any time or any communication or lack thereof caused you concern that you needed to explore that further?
I'm not sure I understand the question.
Did you at any time have any concern about his mental capacity to understand the negotiation process in this case?
Perhaps I'm being too technical with it, but yes, I had a persistent concern that he understood the negotiations. And I satisfied myself that he understood the negotiations, absolutely. However, I had multiple meetings with him to try and make sure that he understood exactly what the negotiations were and what they would mean.
And what would you approximate the number of times you or the legal team brought to represent Mr. Nowsch that you were a part of met with him in this case?
I believe I met, Mr. Nowsch was physically met with over a dozen times, but once I get past that number, I don't know.
So it would be well in excess of a dozen times?
Yes, but not specifically related to the negotiation, just in terms of the case in total, over a dozen times.
And that is, for the record, the scope of my question, not just the negotiation process. You're aware, are you not, that there was requested a physical sit-down meeting with the district attorney of Clark County regarding the negotiations of this specific case that your brother Conrad attended?
Yes.
That occurred on 2 different occasions.
I was not aware of the multiplicity there, but I do recall that such meetings happened.
I'll represent to you that at those meetings, the critical component of them was a dialogue with Mr. Nowsch himself and his willingness to serve a certain number of minimum years as a result of negotiations. Are you aware of that component of the negotiation process?
I was not specifically made aware of these negotiations that Conrad was undertaking with the district attorney. I was aware of the outcome and the goal of these negotiations.
Okay, but my question is a little bit more, to use your term, precise in that regard, that your client had a significant input in those discussions about how much time he was willing to do for this case. Number one, is that an accurate representation of your knowledge of Mr. Nowsch's position for the negotiation perspective?
I would say it differently than a specific
Use your own
number.
words then.
I would say that Mr. Nowsch was very concerned about the amount of time that was contemplated by the negotiation. And so in order for him to have comfort with the negotiation as it stood, Conrad undertook to try and get a better feel of where he believed that the sentence would come down in order to make the underlying plea palatable for Mr. Nowsch.
And part of that, as you knew, and as an experienced defense lawyer that you are, the offer was for a period of in excess of 9 months leading up to the March 2016 entry of plea in this case to be in essence the same offer from the state, that is second-degree murder with use of a deadly weapon.
I would have to disagree. In reviewing my notes, what I believed happened is there was a negotiation that was offered in, I want to say around about May of 2015. And then what happened is as we got closer to the deadline in September of 2015, there was a change made to that offer. And in my notes, it appears that somewhere between September 9th and September 11th, there was a change made to agree to concurrency in that offer.
Concurrency to the unrelated case than the murder in this department.
Correct.
But
My notes are not entirely precise on that, but that's, I believe a change was made at some point there. But you are correct in that for a significant period of time, perhaps 6 months or more, maybe 7 months. Did you say, I think you said 9 months.
Yes.
The offer had remained the same.
As it relates to this case.
As it relates to this case.
And so, for purposes of precision, I'm only going to refer to my following questions as it relates to this case and not the other case, okay? So in this particular case, the state's offer was consistent in a second-degree murder with use of a deadly weapon. Is that correct?
Yes, for a significant period of time.
Now, was for that same significant period of time, under your obligation to promote and to communicate that to your client, was that offer related timely when it was first made to Mr. Nowsch?
Yes.
So once again, that protracted period of time, let's just say for the sake of argument and safety here, well in excess of 6 months.
Yes.
As part of that, did you discuss with Mr. Nowsch the concept of the deadly weapons enhancement under Nevada law?
Yes.
What did you tell him?
Prior to the expiration or the original expiration date on the offer in September, I had a lengthy discussion with him, both verbally and in a written form, to make sure that he understood the consecutive nature of the deadly weapon enhancement and the possible range of penalties associated with it.
And what did you tell him about the potential range of penalties of a deadly weapons enhancement?
For deadly weapon enhancement by statute can be anywhere between 1 and 20 years in a case like this, up to a maximum of 8 to 20 years, or a low of 1 to 3 years. But it has to be somewhere between that 1 and 20 gambit, and it must run consecutive to the underlying charge of second-degree murder.
How many times do you think you told Mr. Nowsch that? Either directly or in your presence?
A lot. More than a lot. I wouldn't be able to put a number on it, but certainly over 10, over 20 times, because it would come up multiple times for each meeting that we specifically had about the negotiations.
And obviously, under the framework of this offer for multiple months, the deadly weapons enhancement, as a practical term, also has a significant effect on the actual amount of time someone will serve in prison. So it's a pretty important component of a plea negotiations. Would you agree with that?
It can be, but the other concern here was the deadly weapon component had a built-in limitation in it. It had a maximum of 20 years. So no matter what happened there, it could be no more than 20. What also needed to be conveyed to him is that count would not, without that enhancement, that second prison term would not even begin to run until he was paroled on the underlying murder with use. And murder with use had the capability of being a 10 to 25, but also a 10 to life. So if it was a 10 to life count, then that second count, my understanding to this day, is that prison will not run the deadly weapon component or even start giving credit for the deadly weapon component until you are paroled on the underlying murder with use count. So if he had a life count there, then it really was life. The rest of his life was a possibility, but at some point, if the parole board said, okay, we're going to parole you on a murder, then at that point, the deadly weapon charge would start running, and then he'd have to be paroled on that count.
And you explained that to Mr. Nowsch, your client?
As best I could, both verbally and in a written graphical form.
And we'll get to that in just a second. At any point, you did not pursue any type of outside consultation because of concerns of your client's ability to comprehend what you had related to him in the negotiation process, correct?
Not specifically, I'm not quite, are you asking whether I hired people to look at his mental health?
My question is, in this particular case, at no point did you pursue an outside consultation as you had described earlier when you had clients that you had slight or significant concerns about their comprehension. You never did that in this case.
That's correct.
And you never did that in this case, not because of neglect or mindlessness in the approach to your profession. There wasn't anything that occurred in your multiple interactions with the defendant or his family or anything about this case that caused you concerns to do that.
That's correct.
Now, you described that there was a graphing of this information about the negotiations. Can you describe what you did in your visit with Mr. Nowsch in this regard?
There was a, I know that it happened in our meeting on September 11th of 2015. And I drew out on a sheet of paper how I believe these sentences would work under the negotiation, both in this case and in Judge Tagliati's case. And essentially I just drew a series of lines and dots on a sheet of paper to try and illustrate for him how these charges would functionally be run in prison.
And that included both the offense of second-degree murder, correct?
Yes.
The deadly weapons enhancement associated with that murder charge, correct?
Yes.
And the companion but unrelated case where the state alleged he took a knife to a juvenile's throat in another department.
Yes.
And was there any concerns based upon your meeting with Mr. Nowsch then or in the future that he didn't understand the term of years and the calculus of time?
Well, perhaps I'm being inartful, but yes, of course, it was always a concern. That's why I went to such lengths to make it plain and understood.
And after you had made it plain and understood, was there any concerns to you that that was not being received by Mr. Nowsch accurately?
No, I don't believe that there were any concerns that he wasn't receiving it accurately.
I want to talk to you about the discovery process as it relates to you and Mr. Nowsch, and I mean discovery in the legal context, of discovery of material provided by the state, or that material gathered in the defense investigation of Mr. Nowsch. Okay? So with that definition of the term discovery, let me ask you a series of questions. Was discovery provided to Mr. Nowsch in this case?
Yes.
If it has been testified to under oath before this court today, that the only discovery provided to Mr. Nowsch was the following: the charging document in this case, the charging document in the knife to the neck case, and a transcript of Mr. Nowsch's statement to police in the murder case, this case. Would that be an accurate statement or an inaccurate statement?
That would be an inaccurate statement.
Can you tell me, sir, what your discovery process was with Mr. Nowsch in this case?
Usually with all of my clients, they get a copy of their discovery. It is redacted to take out dates of birth and social security numbers from victims and witnesses, addresses, because the defendant is not allowed to have that. However, barring that, the defendant has a right to have a complete set of his discovery. However, in voluminous cases like this, there are two complications. First, the sheer volume of discovery is problematic. And second of all, the fact that much of the discovery comes electronically, so videos and things of that nature cannot be given to the defendant if they're incarcerated in CCDC pending trial. So with that, all of his discovery would have been made available to him. Now, there is a caveat, and that is CCDC is a very dangerous place to have discovery. And so frequently I will tell my clients that have voluminous discovery, like Eric, not to have all of the discovery in their room at one time, but to run a relay system. But if they want their discovery, essentially a relay system being means that we bring it into them, and then when they're done reading through it, they give it back to us. Or they do something to secure it, because having that much discovery in the room, the walls in CCDC have ears and eyes. Conversely, they can have it. If they want it, and they're aware of the risks, they're allowed to have that discovery and we'll deliver it to them.
Well, I don't want to get into the hypothetical, I want to get into the reality. What was the process in this case with Mr. Nowsch regarding discovery?
My understanding is that there were some specific visits made with Mr. Nowsch, just drop off the discovery by my investigator or their employees. Beyond that, I typically don't bring in discovery unless it's directly relevant to an issue that I need to talk with clients. So I've been talking with the investigator. It's my recollection that he had discovery dropped off to him when he was in the CCDC.
And you've heard no information from any employee in your office, any information to the contrary?
Correct.
And so you believe, if I understand your testimony correct, that while you may not have delivered it personally to him, but Mr. Nowsch's case was the typical client of yours, where you provided all the discovery minus the redaction portion you previously tested.
Correct.
At any time, do you recall Mr. Nowsch, either directly to you, in your presence, or through any employee of your office, requests for discovery that he did not have?
I think he requested the indictment, another copy of the indictment to be precise, at some point, but I don't remember specifically.
So it's not that he didn't have it, you specifically said he wanted an additional copy because of some reason, but that's the only request during the entirety of your representation of Mr. Nowsch that you can recall ever any request coming from him about not having discovery.
That's the only specific request that I remember. Even then, I don't have a date for it, but let me be very clear. Usually the defendants, Eric in specific, they'd call the office and say, hey, I want my discovery. Hey, I haven't received it yet. There is an open line of communication there. So to the extent that he didn't have something, there's a phone that works 24 hours a day that is used various hours of the day.
And do you recall in preparation for your testimony here today, any type of concern in this particular case about Mr. Nowsch calling your office and discovering being the problem?
Nothing more than the usual. Every client wants discovery. Every client has concerns if they haven't gotten all of their discovery. Every client wants all their discovery, and they call for it periodically. And I believe Eric did that when he felt he didn't have something that he wanted.
And was that request complied with by your office?
To my knowledge, it would have been.
So at the time of your discussions that led to his entry of plea in this particular case in March of this year, Mr. Nowsch never expressed to you any concerns about, I'm not certain about this plea because I haven't received or reviewed any discovery. That never took place.
Not that I'm aware.
Well, just so the record's clear, when you say I'm not aware, I want you to answer to the context of your personal knowledge as well as the knowledge of any representative of your office in the defense of Mr. Nowsch.
I have never received, very quick, Eric never said to me, I won't enter into this plea because I don't feel I have enough discovery. However, as I said, discovery was an iterative process, so he would frequently call about discovery. I do remember one instance, which I think predates him signing the guilty plea saying, hey, can you get me another copy of the indictment? But aside from that, I do not remember any specific issues with discovery in Mr. Nowsch's case other than the constant fighting about it.
Would it be an accurate statement that the contents of the written guilty plea agreement in this case that your client and you signed in March of this year had been discussed with him multiple occasions in advance of his actual formal entry of plea on that day?
The operative portions of the agreement would have been covered with him. However, what I call the boilerplate with my clients and the agreement itself would not have been shown him until probably he got to court.
And the legal requirements of the four corners of a guilty plea agreement was discussed with Mr. Nowsch multiple times and in advance of its formal entry of plea and canvass by Judge Villani in this courtroom.
Correct.
Was there any communication directly or indirectly by you or any member of the defense team to Mr. Nowsch discouraging him from asking questions during the formal canvass process in court?
When the judge is canvassing him?
Yes.
I mean, I don't have any specific memory of it, but I would tell you my normal practice would be if he tried to speak up, I would tell him, no, you need to ask that question to me, not to the judge, because he really should have had all of his questions answered before he enters his plea. He shouldn't be asking the judge.
Okay, so
at that point.
let me make the transition to what I believe you're testifying to as habit and custom in your practice and apply that to the realities of what occurred in the representation of Mr. Nowsch in this case. Number one, is it your testimony here today that you applied your habit and custom in your practice as you just described to Mr. Nowsch? That in other words, you described that process during the formal canvass in advance of his entry of plea, that if he had any questions, to address it to you, not to the court.
Yes.
Was there any concerns of yours that Mr. Nowsch didn't understand that directive?
No.
Was there any concerns during the actual canvass that he had concerns about that process?
I don't remember.
But as you sit here today, you don't recall any incident during the canvass that caused you concern?
Correct. I haven't reviewed the transcript, but I don't recall any as I see it.
And after the entry, formal entry and canvassed by the court, were there any communications with your client that gave concerns to you that directive was misunderstood or confusing to your client?
Well, the directive is if he has any questions, I should resolve those for him before he gets in front of the court. So, no, there were no concerns that he had questions that had been unresolved after his entry of plea.
There was, in the mental health / medical records of Mr. Nowsch, multiple incidents where Mr. Nowsch had made homicidal threats to kill other people and to kill large groups of people. Is that accurate?
I cannot recall specifically.
You would agree with me that the records reflect numerous cases or incidences of homicidal thoughts by Mr. Nowsch?
I remember suicidal ideation, and I remember having the general impression of some of those instances, yes.
And there were also suicidal ideations,
Yes.
and there were also numerous occasions where Mr. Nowsch was diagnosed by more than one mental health professional as being paranoid.
I don't remember the paranoid diagnosis, I'm saying.
But for purposes of our hearing today, I'll make representations to you that the mental health records reflect that. Would that have been something of a concern to you in the defenses, the actual trial defenses in this case? The threats of homicidal ideations and the threats of paranoia as it relates to the facts of this case and your ability to defend Mr. Nowsch on a theory of self-defense or defense of others based upon the content of the interview Mr. Nowsch gave the homicide detective.
I'm going to object to the relevance of this. We haven't gotten into defenses, discussions related to defenses, or anything relevant to what would have made a fruitful or unfruitful defense as this proceeded to trial. It's outside of the scope of the pleadings.
Mr. Stanton, your response?
Yes, the motion itself, page 7, lines 21 through 24, put this issue directly relevant before this court.
Can I ask first, which are you referring to the motion that I filed or the motion that was withdrawn that my client filed?
Counsel's written motion that's before this court this morning.
And then to that, if I could just respond, it very, very clearly states that the mental health history and the implications that those diagnoses have on the ability to comprehend information and make fully informed decisions regarding whether or not to plead guilty. It has zero bearing nor allegation raised on anything related to a potential defense. And that was the limiting order that the court also signed when that attorney-client privilege waiver was signed. We did not read anything related to defenses. I have not gotten into that whatsoever.
Mr. Stanton, could you restate your question so, after argument, can you please restate your question?
Certainly. My question to this witness, Your Honor, was whether or not that aspect of the mental health records, that is diagnosis that his client, my review of the records indicate on multiple occasions had homicidal ideation and had been diagnosed as being paranoid. My question was whether or not that diagnosis had concerns to him about the evaluation of his ability to defend successfully this matter in front of a jury trial in this case. The relevance is directly tied to the recommendation and the communications with the defendant about the entry of plea in this case, which I think is, to some extent, at its core.
Before you respond one more time,
Of course.
counsel, let me just look at the bullet
discuss, nor are we making allegations related to whether or not the legal team discussed with him what potential defenses would be available for him if he were to go to trial, nor are we raising any allegations related to any conversations that might have contained counsel's opinions as to the likelihood of success or non-success on said defenses if they were in fact discussed. We are not touching on that in any way, shape, or form, and that is why we were so careful to word the allegations as we worded them.
I'm going to sustain the objection.
Yeah, Your Honor, I just note that the claim is also about, on the top of page 8, line 1, withholding of discovery. Is the court finding that the inquiry of that information, his mental health, the facts of the depicted as I've outlined them in the mental health records, be irrelevant for purposes of this court's decision of any fact or law before it?
Restate that question.
Certainly. My question is, I believe it's relevant to this court to determine in its totality of the law on the issue of motion to withdraw a plea, that the discussions and the issues that have raised as to the infirmity of the plea by the current team of counsel is the discussion and the disgorgement of discovery. This portion of the discovery, I think, is relevant because it has to do with the discussion with the defendant about the advisement of the plea to second-degree murder with use of a deadly weapon based upon counsel's assessment of discovery. Now, if the court finds that that portion of or component of it is irrelevant for the court's determination today, I'll move along.
Well, counsel has stipulated here that whether or not it was, she stipulated here that they are not alleging that the plea that was obtained, or the offer of negotiation that was obtained in the district attorney's office was not appropriate.
That is not the allegation here.
Correct.
That's correct.
And we do have testimony that Mr. Claus reviewed and discussed with both him and I believe Mr. Nowsch's mother, his mental health issues. He has testified that he has, in fact, provided all the discovery. That's his testimony to the defendant, and the only issue that he recalls being missing was a copy of the indictment.
Well, I think in the legal portion of this proceeding, hopefully that we're going to get to in just a second, my position is that I don't think either counsel from either party in this case has a significant disagreement of the legal standard that the court needs to apply to the facts today. My understanding from the Nevada Supreme Court, under what I think is the operative law, that being the Stevenson case, that this court has, in essence, an obligation to assess whether or not the plea should be withdrawn, quote, for any reason where permitting withdrawal would be fair and just. It's rather broad language, and I think, and the purpose of my inquiry in regard to Mr. Claus and my last objected to question, I think addresses that in part. And thus my question to the court is, if the court believes that that inquiry is irrelevant for purposes of applying that standard, then I have no further questions to Mr. Claus this morning.
I do make that finding based upon the points that the defense is pursuing on this issue.
And their statement that they just made about the stipulation in that regard.
Absolutely.
Thank you, Your Honor. I have nothing further.
Cross-examination. I think counsel approach, please, on the scheduling issue.
really getting into things, I just want to clarify that last line of questions that just took place. Mr. Stan asked you a series of questions related to mental health records. Did you ever subpoena yourself any mental health records in this case?
Yes.
From where?
Children's Hospital, I believe.
Did it? Previously, you were ordered by this court to produce your full file in this case to the defense, is that correct?
That's correct.
And there were follow-up conversations regarding what the defense believed potentially was missing from your file, is that correct?
Yes.
And in fact, you were contacted both in writing and by telephone a number of times related, you or your office, I apologize, I don't mean to impart this on you. You or your office were contacted a number of times through multiple methods seeking any investigation you did or your legal team did in the context of mental health investigation, is that correct?
Yes.
And it was represented to the current defense team that we had been provided with everything your office maintained.
That's my understanding.
And the documents that were provided by your office were limited documents that were provided by the client's mother to your investigator.
That was an error.
So you're saying today that you in fact did additional investigation that was not turned over pursuant to the court order?
If you didn't receive it, apparently it wasn't turned over to you. But I only know this because as I was going through the box of materials from Mr. Nowsch's case, I came across a subpoena and a subpoena return from Children's Hospital. I can't remember the exact name of the organization, but in that we received a number of his records.
Okay. And when you refer to a box that you were going through, what would that box be if I am under the impression that I possess the file?
My understanding is that everything that we received was digitized in one form or another. So even though we might have received these mental health records, in paper form, we would have scanned them in and then put them under a subfolder. And so part of what you received, I thought, was not only what the state had given us, but also the subfolders of all that discovery that we had conducted as well as subpoena returns.
Okay. We can come back to that in a moment. In addition to the Children's Hospital records that you state your team in fact subpoenaed, were there other facilities that you in fact subpoenaed?
Yes, there were, but I don't recall their identities, and the records were relatively limited.
Okay. When you were answering the questions of the state a moment ago, what records were you referring to?
Can you be more specific?
The state simply said, did you review mental health related records, and asked you a series of questions in relation to that, and you answered those questions. What records are you relying on?
There were records that were produced directly from Judge Herndon, starting at 2 months, relating to the father's case. Now, these records did not directly bear on Erich's mental health, but they indicated that the father had dropped him on the pavement at 2 months of age, for which the father was prosecuted. So that was the first set of, I suppose you'd say, mental health records that were in the file. So they didn't directly relate to Erich, but they did describe the incident, and they did have medical records, I believe, associated with the injuries that he'd suffered. So, and then from that point forward, his next set of medical records start at about the age of 7, if I remember correctly, when he was starting, when he had begun being treated with various medications. Those medical records run through, I want to say 2014.
And in relation to those records, how were those records obtained?
Through a variety of means. As I said, the Children's Hospital was one of them because he was under their care primarily for cardiological concerns. But as part of those records, they also indicate that, and it might be Children's Heart Hospital or something, but as part of that, they also document the medications, the psychotropic medications that he was prescribed during various time periods. They're not directly related to his mental health, but they show you know, the medications that he was on.
Okay, and you haven't stated anything that sounds to come direct from a mental health facility. So what is it you're relying on when you say that you read records that related to suicidal ideations and or any other type of ideations?
There were mental records that were received, well, and I didn't finish, but
Oh, I apologize.
his mother had a number of records that she brought in, both from providers and that she had taken herself in terms of notes. She kept a journal, almost a daily journal, going down to Erich's bowel movements, if I remember correctly. And then we did get some records from the medical providers talking about, Mr. Stanton indicated, the antisocial, was it antisocial? No, it wasn't short of, it was short of this, antisocial was, I can't remember.
Paranoia was the topic that you were questioned on.
That's what Mr. Stanton was referring to, but that wasn't my understanding that was a formal diagnosis that had been made when he was younger. It was ADHD, attention deficit disorder. There was some indication of, was it schizophrenia, and also oppositional defiant disorder, I think is what it was, which is...
Okay. And as you sit here today, your testimony is that you, in fact, did cause for these documents to be collected.
Yes.
And that you received and reviewed them.
Yeah, at one point or another, yes.
And that despite both requests from the defense, subsequent court orders from this court, you have no explanation as to why those documents were never turned over.
To the extent that you did not receive them, no, they should have made their way to you.
Well then, moving on for the moment. You came to be involved in this case after being associated with your brother who had been retained on the case, is that correct?
Conrad?
Yes.
Yes.
So it was your brother Conrad who was initially hired on this case. He then associated you into the case and the two of you handled the representation on this case, is that
Actually,
correct?
I think that my fee agreement was signed in this case. And I was brought into it fairly quickly, so I suppose you could say he associated me in because the phone call, I believe, did come to his office.
Okay, and who comprised the rest of the legal team that you mentioned throughout your testimony?
Well, Mr. Stanton mentioned legal team in a rather expansive term. Are you talking about all the experts that were retained?
I'm asking the members of your office that were working on this case on behalf of Mr. Nowsch.
Well, it was both Conrad and my office working on this case at various times, though I was primarily tasked with it. The members of Conrad's office at that time included Conrad himself, his wife Aisha, Victoria Palmer, and James Gonzalez.
Aside from Conrad Claus, are any of the other individuals you named attorneys?
No.
Okay, continue.
Then from my office, it would be myself, Toby Caperon as the investigator, I'm not sure about the other staff that were included at that point. There were other experts.
And you say that Toby Caperon is an investigator, presumably
Licensed
also
private
not an
investigator.
attorney?
Correct.
Across both offices, you stated that there were numerous meetings throughout the course of the case with both Erich as well as with his family. Is that?
That's correct.
And during those numerous meetings, with Erich specifically, did you have to cover the same types of material multiple times?
I suppose so.
And in following those meetings, would you have conversations with his mother or his other family members, keeping them apprised of the state of the case?
Generally speaking, though they had a direct line into Erich, and while those phone calls were and are tape recorded, would not generally discuss the specifics of what Eric was discussing with me. Yes, to the extent that they wanted to have a meeting, they could come in pretty much at any time and we talk about the status of the case. Prior to all the court hearings, which I think they attended, they usually have some questions, either both before and after.
Okay, and when I say that you were keeping them apprised of the case, what I mean is you were telling them what stage things were at.
Certainly.
Or, you know, we've received the following items of discovery at this point, and so we're working through that.
To an extent, yes. I don't think I would have gotten into the specifics of what we received and what it might or might not have said on phones and things like that. So
The family, as well as Eric, were made aware of the fact that you were both pursuing trial investigation while simultaneously pursuing the potential of a resolution in this case.
correct.
And the various updates related to that ongoing conversation related to potential negotiation was discussed both with Eric as well as with his family.
Absolutely.
During the course, let me strike that. You testified today that despite being made aware of some potential mental health issues and or learning disabilities, that your concerns focused on a question of competency. Is that a fair way of stating what you testified to?
No. If my concerns, you mean competency to be at a trial?
Well, the question was posed to you, did you have any concerns regarding Mr. Nowsch's ability to understand? You responded to that by stating, well, and you went down the line discussing competency-related concerns and the potential of referring to a competency court. Do you recall this line of questioning?
Yes, I do.
Okay. Short of competency determinations, would you agree that mental health as well as educational deficits can come into play in a case?
Absolutely.
And would you agree that those are areas that, as the counsel of record, you need to be aware of when discussing critical matters with your client?
Absolutely.
And as you described, you know, every client is somewhat different, and in this particular situation, you had some pointed concerns given, one, his youth,
Yes.
as well as what it was he was able to comprehend from your meetings.
Yes.
And because of that, you stated that you had, that you took the time to have a multitude of discussions with him on a variety of topics.
Yes.
Did you, at any point in time, look into what his educational deficits actually were?
Insofar as they had gone undiagnosed, you mean?
Insofar as anything, did you take any steps to learn additional information related to his educational deficits?
Other than the subpoenaing the mental health records and being given them by the family, and no, I don't recall any specific steps.
Did you subpoena his Clark County School District records?
Not that I'm aware of.
Did you subpoena his individualized education plans as mandated by the county? The plans mandated, not the subpoena being mandated.
Not that I'm aware of.
Did you have an opportunity to review any of the specialized steps that have been afforded to him in the past to ensure he has the capacity to understand a particular issue?
Are you talking about in the court system, or are you talking about
In the court system, in the school system, in any system?
To my understanding, he was never given any special considerations in the court system. But beyond that, I don't know how to answer that. I looked at his mental health records to determine if there was low functioning or capability of impairment. Finding no clear diagnoses there, other than the rather odd medication for antipsychotic medications at 7 years of age. And Eric saying that he actually functioned better without those medications at about age 14 when he started self-medicating with marijuana. And I believe he still remained on lithium after that point. If it didn't affect competency, well, I did look into that. That's the problem. His mental health records were problematic.
Okay. I'm specifically asking if you've looked into anything related to his educational deficits. Take medical
Okay.
and set it aside. Doctors, set it with medical.
Not that I'm aware.
Okay, thank you. You mentioned that you had concerns related to the idea that Mr. Nowsch had previously been involved in the court system, and you specifically stated the juvenile court system. Do you remember stating that?
Yes.
Are you aware that Mr. Nowsch has no contacts in the criminal court system prior to this arrest?
That's not what his PSI indicates.
Would you recall that you actually notified this court that the PSI contains errors that needed to be corrected?
I don't recall that specifically.
Okay.
May I look at my notes for just a moment, please?
That is not my call.
If you need to review your notes, refresh your recollection to better answer
Regards
the
to
question.
PSI, please.
All right, go ahead.
Okay. Yes, I do, but the comment that I made to the court was relating to what appears that he looks to be the perpetrator of an abuse or beating when he was 2 months of age. And that was included in his PSI in error. But there
Right.
are other items contained in his PSI relating to his contact with the juvenile justice system from age 13.
And are you aware that none of those resulted in actual court action?
My understanding is one of those did resort to court action.
Okay, if that was your understanding at the time, that's fine.
And counsel, when you refer to court action, are you talking about a conviction, or are you talking about an entry in the juvenile record, juvenile system?
Either. Well, I mean, an entry is made at the time of arrest, so there's always going to be, or detainment, you know, with the juvenile, so there's always going to be an entry. I can see there's an entry. Yes.
All right.
My understanding is that actually,
Now,
if I may, my understanding was that there actually was a formal referral process in the juvenile system at the
okay,
age of 17.
if that was your understanding, that's fine. I want to talk now about the actual conversations that took place relative to the deal that's ultimately entered. As I understand it, over the course of your representation on this case, there were 2 different offers extended. The first of which happened very early on in the case, is that correct?
Yes.
And do you recall what the offer was at that time?
Not the specific offer that was discussed. The notes that I have refer to what ultimately became the final offer in September 11, 2015, and then moving forward.
Okay, but there was an offer extended prior to that. Roughly 1 to 2 months into the district court proceedings.
I'm not sure if it was a formal offer that was conveyed. There were settlement discussions that were had, but I know that the brass tacks of it and it being withdrawn did not get down to until September or so.
Was there a contemplated offer that was presented to Mr. Nowsch prior to the offer that we are currently here on?
There might very well have been, I don't recall.
Well, I mean, we have obviously spoken prior to your testimony here today. Do you agree that you had a conversation with Mr. Nowsch about an offer or the potential of an offer that differs from the offer we're here on today?
Yes.
Okay. When did that take place?
The specific date, I don't know.
Roughly. Do you recall what Mr. Nowsch's response to that early discussion related to offers was? Was he interested in the offer that was being contemplated or not?
He wasn't interested in that.
Okay. Based upon that, did you or your brother Conrad go back and continue to pursue negotiations with the state?
But we've continued to pursue negotiations with the state.
were you the person that was involved in those meetings?
No, I was not.
Who was involved in those meetings to
Well,
your
when you say
knowledge?
those meetings, let me clarify.
Of course.
I had discussions with David Stanton about various forms of negotiations. When the negotiation ultimately solidified, and he took position as to what it was, that is when Conrad took over and started talking with Mr. Stanton, and ultimately Steve Wolfson, about bettering the negotiation. So we both had discussions with the state about the negotiation.
Did you partake in the meetings that occurred between Mr. Conrad Claus, Mr. David Stanton, and Mr. Steve Wilson?
No, I wasn't present at any of those.
Okay. Following those meetings, was a formal offer extended to Mr. Nowsch?
I believe so. Well, I think the offer had been extended prior to those meetings, but the meetings that Conrad was conducting were with an eye towards improving the offer.
And who in fact went and presented that offer to Mr. Nowsch?
The final offer?
The offer that the next time you had a conversation with Mr. Nowsch related to negotiations. We have the one that no one was interested in. There's now been a series of meetings. Who then goes back to Mr. Nowsch and says, hey, there's something new on the table?
I don't recall that's exactly how it worked in terms of something new on the table. My recollection is we had a number of discussions with Mr. Nowsch about negotiations. Those culminated in September of 2015, where the state was essentially taking the position the offer is going to be revoked if it is not accepted by the state.
Okay.
And so there were a number of meetings. I know of at least one meeting that was had with Erich where we went through the negotiation in great detail and what it could possibly result in terms of prison time. That negotiation is ultimately what he entered into, I believe, in April of this year.
And just for sake of clarity, the plea was entered into on March 4th, and that's what is filed stamped. Do you just state that for any reason?
No,
Just exactly, for clarity. Well, let's talk about the meeting you specifically remember. What do you
the inner workings of what would ultimately be the deal that he accepted in, I think it was March of 2016.
During, you stated those meetings were on September 11th. During that meeting, was it decided whether or not that offer would be accepted at that time?
He decided not to accept it at that point.
Okay. So you continue to move forward, and between that September 11th meeting and the March 4th date in court, were you continuing to discuss negotiations, specifically that negotiation with Mr. Nowsch?
We did have discussions about it, yes.
And ultimately, did there come a point in time where you had a meeting within days of coming into court and signing it?
Probably.
Do you remember that meeting?
The specific date? No.
Not the specific date. Do you remember having a meeting just days prior to coming into court and signing the document?
Oh, certainly. I had a number of meetings with him, I should think.
Okay. During those meetings that are contemporaneous to the signing of the document in court, do you recall what you were discussing with Erich?
Yes.
Were you talking to him about the possible sentences that could be received?
Yes.
What did you tell him the possible sentences that could be received were?
Well, the possible sentence that he could be received had already been explained to him very thoroughly in September.
Okay.
I went back through those again. But at this point in March, what had happened is Conrad had undertaken meetings with both the district attorney and with Judge Villani to feel out where the judge was going to come down on the sentence to the extent that it even could be ascertained.
Okay. Based upon your knowledge at that time, at that meeting, did you advise Erich as to what you believed he would receive if he proceeded forward with this negotiation?
What the judge would ultimately sentence him to? Probably, yes, I believe so.
What did you tell him he should expect as a sentence in this case?
I believe Conrad told him that he felt that he would come into the range of 13 years to some upper amount.
Did Erich pose questions to you related to those numbers?
Yes.
And ultimately, does there come a point in time where it's decided that a guilty plea is going to be entered?
This is after meetings with Erich and his family, yes.
Okay. When is the first time that you provided Erich with the paper document that encapsulates the negotiation?
Probably here in court.
Probably, or yes or no, and do you know?
It is my custom to do it in court. I know that he got a copy of it in court. I have no memory of any staff giving it to him, or no reason to believe that it was given to him before he got into court.
Do you recall going over the guilty plea agreement with Erich in this case?
Yes.
And when you did
I
that,
was sitting there.
and when you did that, did you discuss with him the paragraphs beyond page 1 that talk about sentencing ranges?
Yes.
And did you tell him that at the end of all this, ultimately everything is up to the court?
Yes.
Now, following the entry of plea in this courtroom, did you attend a PSI interview with Erich?
Yes.
Did there come a point in time in that PSI interview where Erich voiced concerns about information he was receiving from the PSI writer?
At the end of the interview, yes.
What were those concerns related to?
Erich said he didn't want to do that much prison time.
Okay, and what is that much? What had been said that triggered this response?
PSI writer went through the possible range of penalties with him, and for lack of a better description, I could see Erich processing. I think I said to you, alcoholics call it a moment of clarity, where you can tell somebody sees something that they didn't before. And at that point, he and I have a discussion about him not wanting to go forward with the plea.
And did he express to you that that was the moment at which he realized these are consecutive terms within the second degree with use of a deadly weapon?
Erich did not break it down that finely. He simply came at it and said, I don't want to do that much prison time.
Okay. And did he, as you stated, he seemed to be having a moment of clarity. Did it seem to be the moment at which these items were clicking in his mind as to what they really meant?
Well, I would object to the speculative portion of the question.
I'm asking his impressions after dealing with his client for well over a year at that point. I think he's able to make observations as to what he thought was happening. It's what he bases his next conduct off of.
Well, he can perhaps describe his demeanor, but as far as what's going on in his mind, it's all speculation to the extent of that objection, I'm going to sustain it.
May I rephrase?
Sure. Well,
Okay, I just wanted to make sure you weren't saying, don't go there at all. Were you under the impression that Erich was just now realizing something?
I would say I was under the impression it had just become real for him.
Did that cause you any concerns related to the concerns you said you always have related to what your clients do and don't understand?
Absolutely. I stayed after the PSI writer left, and Erich and I had a discussion about him withdrawing his plea.
And during the course of that discussion, did Erich in fact notify you that he wanted to seek to withdraw his plea?
Yes.
And did he state to you at that time that it was based upon what had just been discussed at the PSI interview?
Let me, again, we're using our legal terms. Erich did not say, I want to withdraw my plea. What Erich said is, I don't want to go to prison for that long. I don't want to run that risk. I don't want to do this. At which point I would tell him, Eric, you need to withdraw your plea then.
Okay. So his expressed concern was in relation to information provided during the pre-sentence investigation interview.
That's when he came to his, yes, that's when he came to his conclusion.
And the statements that he in turn made to you, you understood to mean he wants to withdraw this plea.
Yes. Well, I mean, that's the only resolution for it. How's that?
I'm just asking what you understood the words to mean. I wasn't in the room. What he said to you, well, clearly not using the language that we would use related to a plea or withdrawing it or anything towards it, did he speak to you in a way that made you respond in turn with a discussion related to withdrawing a plea?
Absolutely.
Okay. Did he ask you for assistance in doing that?
Yes.
Did you tell him that you were unable to do that?
Yes.
Did you advise him to seek assistance from quote-unquote jailhouse attorneys?
I advised him to get assistance from somebody. There had to be somebody in there that could help him write a motion to withdraw.
And when you said you advised him to get information from somebody in there, we're talking about the jail. And people that are in the jail are other people accused of crimes.
Correct.
Or serving sentences following a conviction upon a crime.
Correct.
Or members of law enforcement.
Law enforcement.
Or some doctors.
Or access to the law library. I don't know what materials you have access to there. But I made it clear to him that I could not file that motion to withdraw on his behalf based upon the usual allegations that are made in that motion.
And the advice that you in turn gave was to seek help from those within his current environment.
Yes.
His current environment being the Clark County Detention Center.
Yes.
That meeting took place within days of the scheduled sentencing date, did it not?
Probably.
And following that meeting, were you present at the sentencing date?
I believe so. I looked at my notes. I believe so.
And your brother Conrad was also present on that date?
Yes, I believe so.
And one of you represented to the court that you believe there to be a motion pending that would have been put forward by Mr. Nowsch at that stage.
Yes.
Based upon that, you had some limited additional contact with Mr. Nowsch, but for the most part, all of your contacts with Mr. Nowsch end within the next matter of days. Is that accurate?
At that particular meeting, that hearing, Judge Villani ordered us to see if we could work it out.
Correct.
So after we had confirmed that he had filed the motion and that it was winding its way through the system, and he really did want to withdraw his plea, I believe that was the end of our contact.
Okay, so that's what I was referring to when I said you had some limited contact in addition, but for the most part, your representation ends within a matter of days of sentencing's
Yes.
original schedule.
Yes.
I want to talk a bit about the discovery. You stated that it is your normal practice, your habit and your manner, I believe is how you described it, to use this relay system of discovery. Is that
Yes.
accurate? Okay. And now, if I understand you correctly, the relay system consists of client requests an item, your office provides the item, client reviews and is finished with the item, your office picks the item back up.
Or it can be mailed back to us, but yeah, put on his books, yes. There's a number of ways. Essentially, it comes into his custody somehow, either through mail or direct contact, and then it comes back out of his custody, either through mail or direct contact, or putting it on his books or something.
Do you keep any sort of records related to that relay system?
No.
Do you keep any sort of documentation related to what you're providing and when?
No.
When you're picking something up and why?
Unless it is an especially troublesome client, no.
Well, you described the topic of discovery with Erich to be, I believe you called it a constant fight. So in this particular case, did you do any of those things?
Constant fight. I don't believe discovery was a constant fight with Erich, and if I said that, that was wrong. The constant fight that I was referring to was a constant fight in court to get discovery. So for instance, after he made the decision to not accept the offer on September 11th, there was additional discovery that came in even that month from the state. And the next month after that, the file review was conducted 30 days after that point with the state. So, as I said, discovery was an iterative process. There was no fighting with Erich about discovery. The fight was solely in the confines of the courtroom and with the state.
You stated that the only specific item you recall Erich requesting was the indictment, and that would be a reproduction of the indictment. You had believed that you already had one.
Correct. I have this memory of walking out of a meeting with Erich and him saying, hey, can I get a copy of the indictment? Sure. We'll get it sent out to you.
Do you recall Erich requesting copies of the grand jury transcript both from this case as well as from his other case?
I don't remember that.
Do you recall being present in the courtroom when that concern was actually addressed by Erich to Judge Villani?
I don't recall that.
Do you recall Judge Villani, in fact, having a discussion with you and your co-counsel related to the need to produce such discovery?
I don't recall that. I'm not saying it didn't happen. I'm just saying as I sit here, I don't recall any of that.
Did you ultimately provide Erich with copies of the grand jury transcripts following the entry of the guilty plea agreements in this case?
After the entry of the guilty plea? I believe he asked for it at some point afterwards, yes.
Did you produce it?
I would not have been the one to produce it to him. I don't recall bringing it in to him.
Who would have been the one responsible for producing it to him?
Staff. It might have been mailed to him for all I know.
Did you ever request that it was mailed to him?
Not that I can recall as I sit here.
Do you recall ever instructing a staff member to do that?
Not that I can recall.
And you would be the individual that would give direction to your employees, correct?
Specifically, in some cases, yes, but generally, as I said, Erich had a telephone access to the office staff, and if he wanted something, all he had to do was call and ask for it.
Okay. It's specific to the issue of the grand jury transcript. You acknowledge that you recall it being requested. Did you do anything to produce it for him?
No, I said I didn't recall it being requested.
Okay, then I misunderstood you. I thought you said that you do remember at some point following the plea that he asked for it.
I don't recall him asking for the grand jury transcript after the plea. It might have happened, certainly. Would it have been done? Certainly. But if I answered that incorrectly, I'm sorry. I have no specific memory of us asking for the grand jury transcript following the plea.
In this particular case, not your general practice, did Erich possess copies of the witness statements against him at the Clark County Detention Center?
He should have at some point.
Did you do anything to document the transfer of those documents to him?
There might be some documentation of that in the investigative fees associated with this because some of them might have been brought into him. But I wouldn't have documented it in my billings or in my case.
And you recall that we specifically, again, got a court order mandating that the full file be turned over to the defense, current defense, in this particular matter, correct?
Nothing was withheld from me.
Okay. So if there are no investigative logs documenting generation of fees in the documents that were turned over, where would those be maintained?
At the investigator's office.
The investigator is your employee, correct?
I pay her and staff to provide paralegal services in my office, but she has a separate licensed private investigative firm. She bills the county separately. I believe they instituted a protocol at the county where I have to sign off on those billings. But I don't typically retain a copy of them at that point. I'm more concerned about the work being done than in maintaining an audit trail of billings. So the county probably has those billings. She has those billings, but I probably wouldn't maintain them in my file. Well, I wouldn't maintain them in my file before she returned.
Okay. Would you agree that the investigative file relative to a criminal case is part of the full defense file?
It can be.
Please elaborate.
To my view, part of the purpose of having an investigator is so that the investigator can go out and talk to witnesses that the attorney doesn't have to. Both because the attorney cannot be a witness, but also because sometimes the witnesses say unfortunate things for an attorney to hear. This can both happen with the client and with the witnesses themselves. So to the extent that those things are not preserved and not given to me, then I do not have to turn them over to the state, even though they might be inculpatory for my client. So if I were to make the full investigator file part of the attorney's file in every single case, then I would run the risk, given court orders, of turning over inculpatory information against my client. I don't like running that risk. Therefore, I don't maintain the investigative file, except to the extent that it aids my client's interests.
Okay, and in this particular situation, not in a general sense, you were served a court order to provide current defense counsel with the full file related to this case.
And to my knowledge, that was done.
However, your testimony today is that the full file of what was turned over to the defense may have parts that are maintained in other offices.
Objection, irrelevant, argumentative, cumulative.
I think I've said.
Hang on.
It is not argumentative. I'm trying to understand whether or not there are materials that were not provided to us. It goes directly to issues that we raised. We would have clearly gone through these materials to see if and how they bear on the allegations we have raised. We would have potentially questioned different individuals during the course of our investigation. And the questions are purely to have an understanding of what the practice in this particular case was related to what was or was not done in terms of production of discovery. The testimony was, I wouldn't necessarily be the one that does that, but I couldn't tell you if my investigator logged it somewhere different, so I'm trying to get to the heart of that matter to understand if there is some other place that should be looked.
And Judge, I believe he's already testified to his procedure in this regard. So A, that's cumulative. B, it's irrelevant because the purpose is merely a documentation or a paper trail of discovery. It's not dispositive one way or another as to whether or not the discovery was even produced or not produced. We have the testimony of the defendant himself who's articulated what he has had in discovery, which is virtually nothing. So what's the relevance of a further inquiry of a paper trail to show one? And I don't think it's dispositive one way or another if there's a billing statement that they went over and visited the defendant. So that's why the state believes that that portion of the objection is that it's irrelevant.
Last word, Murray. Mr. Murray.
I apologize, I didn't hear you.
Last word, go ahead.
No, I think that the court understands my position.
So you want to know whether or not Mr. Claus has turned over everything that his investigator is holding?
Whether the order of the court was complied with, whether the full file was produced or the full file which was maintained by his specific office, which may or may not include the full file of the others on the legal team.
Well, Mr. Claus, just so I'm clear, the file that you have at your office, whether it's in electronic format or in paper format, is that turned over to Ms. Murray?
The electronic format was turned over to Ms. Murray.
Is that a copy of all the paper file that you have at your office?
It should have been, Your Honor. Well, I'm sensing from her that she did not get some of the mental health records that I frankly only remember having seen in the file because I reviewed them this morning. But the practice is to put them into the electronic file.
So far as you know, the electronic file was turned over.
Yes, sir.
Go ahead, Ms. Murphy. I'm not sure what else you're asking.
Simply whether or not there is another file being maintained in another office.
Yes, but Toby,
Well, it's not his file, it's the investigator's file.
The investigator is a critical part of the legal team. When counsel changes hands, if I can just put it in context, when counsel changes hands, for example, if this were a different case and it was a calendar call and counsel were to withdraw and my office were to be appointed and we were to seek from the court a full production of the file, the court would never think that we were going to just get what's maintained by the lawyer in a vacuum. The court would expect that we were also to receive all of the investigation work that had taken up to that place, because that is how we step right in, review the work that's already happened, and proceed from there. Otherwise, every time we stepped in on a case, we would be starting investigation from square one, potentially years into a case. The investigative file is a critical part of the file. And if, by the testimony here today, the investigative file is the location where documentation of discovery being or not being provided would be maintained, it's critical to this issue in this case.
Wasn't the issue in this case relating to the plea?
But the
Being
context,
pressured, whether or not they understood, and whether or not they understood the potential penalties.
and part of the knowing and the voluntariness of any plea entered is an appreciation of the facts as they are against you. That is why we stated the late disclosure of discovery and the limited disclosure of discovery impacted his ability to make a knowing, informed, voluntary decision. So in this particular matter, had Mr. Claus stated, yeah, I'm the one who brought them back and forth, or no, I'm not the one who brought them back and forth, it was never done, or anything of that nature, it probably wouldn't be relevant. But that's not what he said. What he stated was, my investigator might have done that, and they would have maintained, potentially, documentation in the following format.
Well, he also testified that he was never advised that Mr. Nowsch was missing discovery, except for the indictment.
And potentially a grand jury transcript, and there was, in fact, a court date where the court intervened in that matter.
So this is more towards the area of turning discovery over versus exculpatory.
It has nothing to do with
exculpatory
exculpatory or inculpatory. No, I completely agree. It has nothing to do with what that discovery would have said. It's purely an access issue. The court's going to be asked ultimately, do I think he had enough information to knowingly and voluntarily enter into this plea? And as Mr. Nowsch has testified, he didn't have the discovery. As Mr. Claus has testified, his normal habit and practice is to provide the discovery. When pushed further down that road, the question became, who would have been responsible for that? How would it have been done? And would it have been documented? That's potentially another file, another office. And I think that's where it's at.
You said perhaps in excess of a dozen, I believe you said.
yes, sir.
Did you discuss discovery with them? I didn't say the police reports.
Yes, sir.
And did you have those with you at the time? Did he have those with him at the time?
I probably had them with me at the time. I carry, whenever I'm going to go in and have a discussion with the client about that, I usually take it with me electronically.
I'm fine with that. I'm satisfied with that.
Okay, thank you. Any other questions?
Now I've lost my place.
Well, I mean,
Brief indulgence.
I can also say, there were notes that I've uncovered where I've said to Eric, when you're talking about taking this deal or thinking about taking this deal, I want you to look through, read the discovery, and in your own mind, come up with questions, come up with the positives and the minuses. And there were notes of that back and forth process, which could only be had if Eric had the discovery. Now, if you're asking me what specific, I'm answering a question that's not happening.
I would agree.
Well, let me follow up so I make sure I'm clear. So when you made that statement to him, did he ever say, what discovery? What discovery are you talking about?
No, Your Honor. He did not say what discovery.
Go ahead, counsel.
And actually, at this time, I'm going to pass it.
All right. And full counsel.
I am getting told I'm not passing this witness.
me ask you a series of questions dealing with the evidence in this case against Mr. Nowsch, both in the guilt phase and the potential penalty phase, if a penalty phase was had, either through trial or through plea, okay? Based upon your review of that information, to include the mental health history and medical records of Mr. Nowsch, would you agree with me that the evidence that you might use as a mitigation could actually be used as an aggravation against him, and that was part of your calculus and communication and advice for a knowing and intelligent plea of Mr. Nowsch to the deal that's subject to this motion today?
Yes.
Nothing further.
Any recalls?
Great conditions.
All right. Thank
Oh,
you.
yeah, I apologize, no problem.
All right. Thank you, counsel. For your time, you're excused. Any other witnesses for the state?
No, Your Honor.
Any other witnesses for the defense? All right, so we will come back at 1:20, and I'll hear argument from counsel.